First District Court of Appeal is now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Good morning. You may be seated. Welcome to the First District Court of Appeal. We have two cases on the docket this morning. We will take them in the order in which they appear on the schedule. First is Cohen versus Autumn Village, case 20-2206. Counsel for the appellant, you may proceed when you're ready.
May it please the court, my name is Terry Bork, and I represent the appellant in this action, Ms. Cohen. And I'd like to reserve 4 minutes for rebuttal.
Okay.
And the issue in this case, well, we contend that the trial court in this case erred in dismissing Ms. Cohen's complaint with prejudice. We submit that a textualist and supremacy of the text analysis of the Assisted Living Facility Act would establish that in the case against a licensee, the Act only covers a professional negligence action, and that an ordinary slip and fall premises liability case can proceed. The case that's important, the advisory opinion of the Amendment 4 of the Supreme Court establishes that as of now, a textualist supremacy of the text analysis is what all courts in Florida must apply in examining statutes. And under such an analysis, the words of a governing text are paramount, and what they convey in their context is what the text means. And every word in the statute is to be given its plain, ordinary, common sense meaning.
Counsel, and I agree with you on the textualist approach and us being bound by that. Let me ask you about that, though. So in 429.29, it references negligence without any limitation. And if we contrast that with the medical malpractice statute, which references negligence as claims for medical negligence, claims arising out of rendering the failure to render medical care services. It seems like the legislature knows how to limit negligence claims if it chooses to do so, but did not do so in the Assisted Living Facility Act.
Well, we submit that if you look at every word in the Act, that it did limit it, because in the section that defines or negligence or that deals with exclusive remedy, negligence is not defined, but in the other sections, 429.29 subpart 3 discusses reasonable care, and it says the reasonable care is that degree of care which a reasonably careful licensee, person, or entity would use under the circumstances. Well, that makes a distinction between a licensee and a person or entity, because the word licensee would not need to be there if you're just going to have a reasonable person standard. You just use the words reasonable person or entity. And then the next subsection, the next statute, 423.293, subsection 1A, defines a claim as one part of it, a negligence action, meaning a claim alleging the death, injury to, or death of a resident rising out of the violation of the rights of a resident. That's the Bill of Rights. It's not relevant here. Or an assessed deviation from the applicable standard of care. And again, if you look at every single word given in its plain, ordinary, common sense meaning, applicable standard of care tells us that there's more than one standard of care. And looking at the two statutes together, we have a standard of care for a licensee, which we contend is a professional standard of care. That's the applicable standard of care for the licensee. And for a person or entity, then that would be a regular negligence action. But
under subsection 3, aren't they all made part of this statute? I mean, it says reasonably careful licensee, person, or entity. I guess I'm not following why subsection 3 helps you.
Well, the reason is because you've got to give each word its own meaning and ask why it's in the statute. Because otherwise, you're not following, giving the text its supremacy. And here, the licensee would not need to be there if you're dealing with a reasonable person standard.
But person is also there, an entity is also there.
Yes.
I mean, it seems like you're arguing for the statute to be very narrow and to be talking about a specific type of negligence. And in subsection 1, it uses no modifiers, it's just negligence. And in subsection 3, it seems to subsume all sorts of negligence. I mean, it's a broader provision than just professional negligence, it seems, because it talks about person and entity.
Yes. Well, as we understand the section, we have to go back, like, the use of the word licensee and the use of the word applicable, and give them their own meanings. And to do that, we believe that the only sensible analysis is to say that those cover professional actions, or else those words would not need to be there in the context that they're being used. And of course, that's important in terms of the exclusive remedy that's mentioned in the statute. It doesn't define what negligence is. We have to go elsewhere in the statute to get that definition. And, we're left with what the legislature has left us with. It is not by any means a well-written statute, in our opinion, but, the court cannot add in words to the statute to make it mean what they think the legislature meant it to mean. They've got to ask the question, why was the word licensee used instead of just saying person or entity? And we believe that's because the licensee is,
Do you think your case would be stronger if the words person or entity weren't there? If it only referred to licensee?
Excuse me?
Would your case be stronger if subsection 3 only referred to a reasonably careful licensee instead of also including person or entity? Would that make your case stronger if person or entity weren't part of subsection 3?
I'm not sure if it would really make a difference. And, reasonably careful licensee, person, that, so we understand it modifies all three, person and entity as well. But to us, reasonably careful, it helps a bit with the licensee, but the main reference is to the licensee, because you have to ask what makes them different from a person or an entity. Why is the statute saying you have a cause of action against them different? And then why does the next statute say asserted deviation from the applicable standard of care instead of a reasonable person standard of care? It leaves the court free to say what is the applicable standard of care for the three entities that we look at above. And we contend a licensee, well, not just anyone can open an assisted living facility. They have to apply for a license. It's a rather arduous process. One has to go to get that license and to open the facility. And we believe that is what the legislature, in its tortured language, was driving at, because otherwise you just have to write the words licensee and applicable out of the statute, and they have no effect. And that is not something that a court can do under a textualist and supremacy of the test analysis. You've got to give those words their meaning, answer the question why they're in there, and we think that's the only thing that makes everything fit as a whole. It's a little bit like looking at a puzzle, and with those two words out, the picture doesn't make any sense. But when you understand what the word licensee means, and you understand what applicable means and applies those, well, that makes it clear that the licensee has to be liable for a personal action under the Act. And significantly, what that means is that since Ms. Cohen is alleging a slip and fall action against the licensee, doesn't have to provide pre-suit requirements, and it's not governed by the 2-year statute of limitations, but rather the 4-year statute of limitations.
For just a slip and fall in ordinary, what you're calling a common law negligence action, under this statute, why would that not also be a violation of a right provided in 429, the Bill of Rights, as you said, that mandates that residents live in a safe and decent living environment?
Well, in the assisted living environment, the Residents' Bill of Rights, that is applying, in the analysis we gave in the brief, talked about essentially to be free from abuse and to have some freedom of liberty of choice is what is going at there. And that is not what we're basing our cause of action on, and the defense doesn't contend that we're basing it on a violation of the Bill of Rights either. We're focusing just upon the negligence section, which is defined under the Act as asserted deviation from applicable standard of care. The Bill of Rights has a lot of detail in terms of what is a violation of a Bill of Rights. It never does it use the word negligence within those definitions, as I recall. But when it does talk about negligence, it defines it for, a certain deviation from applicable standard of care, which asks the question, well, what's the applicable standard of care? And what's the applicable standard of care of a licensee? We contend it's a professional standard of care and not a reasonable person standard of care. The legislature would have said reasonable person if that's what they meant. And they wouldn't have pulled out a licensee to get special attention under the Act as opposed to a reasonable person. I see my time, I need to reserve time for rebuttal. Thank you very much.
Thank you, counsel. Okay. Counsel for the appellee, you may proceed when you're ready. Take your time.
May it please the court, Thomas Valdez here for the appellee Autumn Village. Your Honors, the trial court in this case properly dismissed plaintiff's complaint with prejudice. This appeal represents nothing more than an attempt to circumvent the applicable statute of limitations, which is set forth in Chapter 429, 429.296. Because that statute of limitation has barred plaintiff's claims. And jumping really quickly to a couple of points that the court made, the legislature does know how to limit a statute where it wants to just to professional negligence. It did that in Chapter 766, and that's why we've seen cases since 766 was passed where the two sides debate, well, is this professional negligence or is this ordinary negligence? So the legislature knows how to write a statute that applies only in a professional negligence context. They didn't do that with Chapter 429. In Chapter 429, in subsection 1, they say the sole and exclusive remedy for personal injury of a resident that's caused either by negligence or a violation of rights is a cause of action brought under this statutory framework, the statutory framework in 429.29 through 429.298. And right below that, in subsection 2, they lay out the very familiar elements of a cause of action. So basically, what they've done is say, hey, we're gonna take any assisted living facility resident that wants to bring a cause of action for personal injury. We're going to allow them a new cause of action, an action for a violation of rights, and we're going to allow them, or we're going to require them, to bring that cause of action, whether it's based on negligence or a violation of rights, under 429, within the framework of 429. Why is the framework of 429 important? Because within the framework of 429 is 429.293, which is the pre-suit notice and investigation requirements of the statute. Within that framework is section 429.296, which lays out the fact that, or says that there's a 2-year statute of limitations for these types of actions. And in 429.298, there's a treatment of punitive damages and their availability in these types of cases. So the legislature has done this before. With Chapter 400, the nursing home statute, they wrote an almost identical statute, and they said, look, including the exclusive remedy provision, said, look, we want all nursing home actions that are based on negligence for personal injury, we want them under the 400 framework. Subsequently,
are you also making a textualist argument?
I actually am making a textualist argument. I think that a textualist reading of this statute requires affirmance in this case. I think that
it does. Where do you point that a slip and fall negligence falls under this regime as opposed to only professional negligence?
Well, Your Honor, in subsection 1, when it says that a cause of action under this section shall be the exclusive remedy for any personal injury to a resident arising from negligence, and as Judge Ray pointed out, that was negligence very generally, or a violation of rights, it must be brought under this section. A textualist view of this statute really doesn't allow for anything else. The argument opposing counsel is making flies in the face of a textualist analysis of this statute, where the statute very broadly says any personal injury, if it arises from either negligence or from a violation of rights, we might call it statutory negligence, must be brought under this section. That's very clear. And the rest of the rest of the sections of 429 refer to negligence and to violations of rights, completely consistent with the exclusive remedy provision language that I just cited.
Now, Mr. Valdez, what's your response to the emphasis appellant places on the word licensee in subparagraph 3?
Your Honor, I think that emphasis is misplaced, respectfully. When you look at the statute, and it's 429.29 sub 3, it says, in any claim brought pursuant to this section, a licensee person or entity shall have a duty to exercise reasonable care. A couple of points that are important about that. The legislature did not distinguish between a licensee, a person, or another kind of entity. It lumped them all together. A second important point is it didn't impose a higher standard of care for licensees, persons, or entities. It said they're going to be required to use reasonable care, and that's ordinary care. Reasonable care, the degree of care which is a reasonably careful licensee, person, or entity would use under like circumstances. So the statute sets out ordinary care as the standard, not a professional standard of care. And hearkening back again to 766, the legislature certainly knows how to say, we're going to require a professional standard of care, and we're going to be so specific about this that we're going to require you to use the same or similar expert to testify. In some cases, the same expert to testify. They go into great detail about what you've got to do to establish this obviously higher professional standard of care. There's no reference in this statute anywhere.
But how about in subsection 4? It seems to put nurses in it there in a somewhat different class. Nurse shall have a duty to exercise care consistent with the prevailing professional standard of care for a nurse. So is it
I agree, Your
Different
Honor.
just for nurses, or?
Yeah, I agree, Your Honor. It is different for nurses. And the way that an assisted living facility works, an assisted living facility is sort of a step between home and a nursing home. These are people that need help, but not the degree of help that someone in a nursing home might need. They just may need help remembering to take their meds on time, or time or housekeeping. They may need to be told to go down and have to have breakfast, lunch, dinner. And those things are done by a lot of people other than nurses, okay? So those are the people that are covered under subsection 3, that ordinary care standard. Now, on occasion, there is some level of nursing care provided in an assisted living facility. Not the same level you would get in a hospital or a nursing home, but nursing care just the same. And so the legislature clearly has recognized that, look, in some instances, nurses are going to provide care, and they're going to be subject to the prevailing professional standard of care for nurses. So they've differentiated sort of between nurses and everybody else at the facility. And if they wanted to, as Judge Ray pointed out at the beginning, they could have done what they did in Section 766. They could have taken a licensee out of subsection 3 away from person and entity, and they could have said a licensee shall be subject to the prevailing professional standard of care for licensees of assisted living facilities. They didn't do that. They subjected them only to a standard of ordinary care that applied to any person or entity. They didn't differentiate. They didn't treat them differently the way they treated nurses, who are medical professionals. The fact that the legislature treated nurses differently really helps my argument, because it shows not just in 766 do they know how to separate out different kinds of negligence. They even know in 429 there are different kinds of care that are going to be provided here. Some of these is not going to be nursing or medical care at all. They're going to be aids that help change a person or help them get dressed. That's not medical care at all. They may help them walk down the hall. That's not going to be medical care at all. That's going to be under the ordinary care rubric. To the extent that they ever get into professional care by a nurse, there's a separate standard of care. But in this case, plaintiff does not ever take the position, or appellant does not ever take the position that the nursing standard of care has anything to do with their claim. They say, hey, this lady, our client, Ms. Cohen, suffered a personal injury. She was a resident of the assisted living facility who suffered a personal injury as a result of negligence. That, going right back to the exclusive remedy provision, that's exactly the kind of claim that has to be brought within the framework of 429. It's exactly the kind of claim to which a 2-year statute of limitations applies. It's exactly the kind of claim that should have warranted, should have required the plaintiff to conduct a pre-suit investigation. But the plaintiff didn't do any of these things. And I'm not casting aspersions on opposing counsel. They may have gotten the case 2.5 years after this happened. I mean, I'm just pointing out the fact that it's almost 3 years after the incident that this case is filed, and this case very clearly falls within 429, given the allegations of the complaint and the plain meaning, a textualist reading of Section 429.29, and particularly that exclusive remedy provision, which kind of brings everything else into focus. I mean, everything else is in much sharper relief because of that exclusive remedy provision. If that exclusive remedy provision wasn't there, if they hadn't included language that says any personal injury claim arising from negligence or a violation of rights must be brought under this section, then maybe there's some room to argue, maybe. I think given the other the sections we've talked about, there really isn't any room to argue. But I think that sort of the exclusive remedy provision language, when viewed in the context of all the other language of these sections of 429, makes it very clear that 429 offers the sole, or is the sole way for plaintiff to proceed. It establishes that this was a 2-year statute of limitations that applied in this case. It establishes that the plaintiff was required to do pre-suit in this case if they were going to bring a claim, and they didn't do any of those things within the 2-year statute of limitations set out in this claim.
What is the purpose of the pre-suit for ordinary negligence claims as opposed to professional negligence claims in a case like this?
Well, Your Honor, it's actually very, I mean, it's very similar in a general sense to put the facility on notice of the type of claim that's being brought against them so that they can investigate that claim and determine whether it's one that's ripe for resolution before a suit is ever filed. So, the only thing that 766, 400, and 429 have in common is they all have pre-suit provisions. And the pre-suit provisions really serve a different purpose and are sort of unrelated to whether we're talking about ordinary negligence or professional negligence. The pre-suit provisions are meant, as I said, to try and short-circuit litigation, to try and sort of get cases resolved early, if you can, by putting the opposing party on notice, doing informal discovery, having mediation, and a lot of cases get resolved that way. Unfortunately, a lot of cases don't. But that's the purpose of those provisions in 766, in 429 and 400. And for all of those reasons, Your Honors, we would ask that you affirm the trial court's decision.
Thank you.
May it please the court, there are two main points I want to make in rebuttal. One of them is there's been a lot of discussion here about, well, the court knows how to write the statute that would have, carved out a professional liability. But, under a textualist analysis, supremacy of the text, we're not supposed to be guessing what a court could have written or what it would have written. The whole purpose of textualism is to get away from that search for the legislative intent and to just say, we looked at the words of the statute. That's what the legislature meant. That's what we're supposed to interpret. And if you look at the words of the statute, you have to account for the words licensee and reasonable care and applicable standard of care. And those have to be given some meaning. And the meaning, we believe, is that licensee has an applicable standard of care that is a professional standard of care, while a person or entity has a reasonable, careful standard of care, and the applicable standard of care is that of common law negligence. We feel that any other endeavor into saying, well, what could the legislature have used? What could the legislature have meant? Is veering away from the text and counter to what Scalia and the whole textualism movement is trying to do. We would also note that very significantly that nowhere does the defendant in their analysis of this statute try to account for the meanings of the word licensee or reasonable care or applicable standard of care. They don't have any argument with saying, well, the licensee really leads us to say this is a reasonable person standard of care, or the applicable standard of care is a reasonable person standard of care when applied to a licensee. They have no argument to make in that ground. The only thing they can fall back on is saying, well, the legislature knows how to write a statute correctly. And that is, I would also say, an assumption that a textualist wouldn't want to make, but, sometimes the legislature poorly writes a statute. That happens. And perhaps the intent here was not to give a licensee, freedom from, to cover, just to cover professional negligence actions. But we don't go by, if the legislature makes a mistake, what the court does is interprets the words used and says, legislature, change it. Make it say what you say you want it to say. Because we're left here with the job of trying to decide what you meant by the word licensee, why you separated that from the words person and entity. We're left here to decide what you meant by applicable standard of care. Why didn't you, that suggests that there's more than one standard of care that can be applied here. And we think that the only plain, ordinary, common sense meaning of those words would be licensee, applicable standard of care, professional, and person, entity. They have a common law negligence action. In conclusion, we would ask the court to overturn the trial court decision below and to let this case proceed to trial. Thank you very much.
Thank you, counsel. Thank you to both attorneys for your presentations today. Take your time. It is. It is. Y'all travel safely back to your homes and offices. Well, I'm glad. Good. It's good to see you both.
Thanks again.
Yes, thank you. Okay, next on the docket is First Call versus Citizens Property Insurance Company, case number 203273. Counsel for the appellants, you may proceed when you're ready.
May it please the court. My name is Eric Diener. I represent First Call 24, Inc. The issue before the court here today, and I would like 5 minutes for rebuttal, please. The issue before the court here today is the proper scope of the appraisal provision contained in Citizens Property Insurance's policy. It is the appellant's position that this appraisal provision only contains an agreement to appraise existing property damage. It does not contain an agreement to appraise repairs that have already been made or expenses that have already been incurred. I would like to start by looking at the appraisal provision itself. It says, appraisal is an alternative dispute resolution method to address and resolve disagreement regarding the amount of the covered loss. Then it says, if you and we fail to agree on the amount of loss, either party may demand an appraisal of the loss. If you or we demand an appraisal, the demand for appraisal must be in writing and shall include an estimate of the amount of any dispute that results from the covered cause of loss. Then it says, the estimate shall include a description of each item of damaged property in dispute as a result of the covered loss, along with the extent of damage and the estimated amount to repair or replace each item. Subsection F of the appraisal provision describes the appraisal award. It says the appraisal award will be in writing and shall include the following: a detailed list including the amount to repair or replace of each specific item included in the award from the appraisal findings, the agreed amount of each item, its replacement cost value and corresponding actual cash value, and subsection H says, if you, we, and the appraisers, you, we, the appraisers and the umpire, shall be given reasonable and timely access to inspect the damaged property in accordance with the terms of the policy. The appraisal provision itself references damaged property throughout. It requires, mandatory, that the appraisal demand be accompanied by a written estimate listing each item of damaged property. The appraisal award has to be in writing, has to include an actual cash value and a corresponding replacement cost value. Actually, it's replacement cost and corresponding actual cost value. The difference between replacement cost and actual cost value under the case law is depreciation. Replacement cost is what you pay to replace something. Actual cash value is replacement cost minus depreciation equals actual cash value. So only assets are depreciable. You cannot depreciate a service.
Counsel, let's parse some of this language out. The first provision, first sentence under the appraisal talks about the amount of covered loss. So do you agree that the emergency mitigation services provided by your client constitute a covered loss?
Yes, Your Honor.
And so why do we not have simply a disagreement about the amount of the covered loss?
Because appraisal does not determine coverage. It determines the amount of loss. You have to start with the amount of loss before you can determine the amount of the covered loss. The amount of loss refers to what the insured, the policyholder, is liable for as a result of the loss. What the insurance company has to reimburse the insured for the covered loss or for the amount of loss is the covered loss. So the amount of loss is what the insured is liable for. The covered loss is what the insurance company is liable for. The appraisal provision starts off saying that appraisal is an alternative dispute resolution method to address and resolve disagreements regarding the amount of the covered loss, but then right underneath it says, if you and we fail to agree on the amount of loss. So you have to actually figure out the amount of loss first, and then you apply coverage, the policy coverages, and then you come up with the amount of the covered loss. The deductible is a perfect example. The insured must incur the first $2,500, $5,000, however much their deductible is. The amount that the insured pays in incurring their deductible is part of the covered loss. If it wasn't covered, the insured couldn't use it to absorb the deductible. Only covered losses absorb the deductible. And once the deductible is absorbed, the carrier is liable for anything above that amount. So the amount of loss refers to the amount the insured is liable for, not the amount that the insurance company must reimburse the insured under the policy.
Let me just ask you as a practical question. If the insurance company disputes that an invoice is reasonable for necessary services, under your interpretation of the contract, how does that dispute get resolved?
Litigation. Appraisal is an alternative dispute resolution process that deprives the non-demanding party of the right of access to the courts due process. That was recognized in Seifert versus U.S. Home. It's a Florida Supreme Court case cited in my initial brief. Because an appraisal or an arbitration provision takes away these rights, the only thing a court has to do to compel arbitration or appraisal is find a clear and unambiguous agreement in the contract to appraise the type of dispute that the demanding party is trying to submit to appraisal. Our argument is this policy does not contain a clear and unambiguous agreement to appraise damages that have already been repaired or expenses that have already been incurred.
Now, I think one of the appellee's arguments is, well, we'll just do the repairs first, and then, then they're responsible for the invoice short of litigation. It's just kind of short circuits any type of good faith on the part of the insured. How do you respond to that argument?
Is it a possibility that the insured comes out of pocket and does a bunch of repairs that are upgrades or betterments? Yeah, that's a possibility. In that case, the appraisal panel doesn't come in and say, okay, well, this is an upgrade, this fan costs $100 more than the fan that they had. Those are issues, that's not what the appraisal does. The appraisal panel does not determine what should have been paid versus what was paid. The appraisal panel determines when the damage is still there and the parties don't agree and don't know what the amount of loss is. This is a binding number that you guys are going to agree to. Once the repairs are made, if the carrier disputes that those repairs were appropriate or reasonable, they have to litigate that issue. You have to explain why were these repairs not covered under the policy. Otherwise, let's look at the flip side of that coin. If an insurance carrier could just demand appraisal whenever the insured completed repairs, the insured would never recover replacement cost value under the policy. If your home is damaged and you spend $50,000 repairing it, and the insurance company, and you submit your invoices to the insurance company, and they say, no, we don't think this was reasonable or necessary, they could demand appraisal, cause the homeowner to have to incur the cost of an appraiser, half the neutral umpire fee, and then if the appraisal panel decides $50,000 was an appropriate number and awards that number, the insured does not recover $50,000 under the policy. The insured recovers $50,000 minus his or her deductible, minus the cost of the appraiser, minus the cost of the umpire. So if you allow an insurance company to demand appraisal of costs that have already been incurred, you are allowing the insurance company to use the appraisal provision to second guess what the insured spent and to use it as a vehicle to try to reduce the insurance company's liability toward incurred costs, which when you look at the policy, whenever it references incurred costs, it says we will pay. If you look at the reasonable emergency measures provision, it says we will pay the reasonable and necessary costs you incur. If you look at the loss settlement or loss payment provision, it's the loss settlement provision, it says we will pay costs as they are incurred and expenses are submitted. In the appraisal provision, it specifically references existing property damage. We also have, now, Citizens argues that the portions of the appraisal provision that are impossible to comply with respect to completed repairs, their argument is, well, in those situations, you just ignore the requirements that can't be complied with in the appraisal provision when repairs have been completed. If the repairs have been completed, you don't have to inspect the property damage, even though the policy says the appraisers and the umpires shall be given reasonable access to inspect the damaged property. I'm unaware of any case saying that you can ignore certain portions of a contract that say shall and that are mandatory depending on the circumstances.
Well, I think that, I mean, in all fairness, I think they point to language like, for example, damaged property, quote, in dispute, close quote. So if there's no property in dispute, then that provision is not applicable. So do you not see that the in dispute language, for example, provides some sort of, limitation on the mandatory, otherwise mandatory language?
My client's invoice is in dispute, and it is an incurred expense that has already been incurred. So you can have an incurred expense that's in dispute, but then when you look at the rest of the appraisal provision, it says the appraiser shall be able to inspect the damaged property, shall exchange estimates, include listing each item of damaged property. When you look at those provisions, they don't apply to an incurred expense. So yeah, the in dispute language could refer to incurred expense, but when you look at the rest of the appraisal provision, it doesn't, the rest of the provision doesn't apply to incurred expenses. So, and the insurance company's argument is that the phrase, the amount of loss, refers to the amount that the insurance company must pay as a result of the loss. That is stated on page 21 of their answer brief. They say loss means the amount for which the insurer becomes liable. That's not what the Fourth District Court of Appeal held in Dulles Fort versus Progressive Express Insurance Company. In Progressive Express, the Dulles Fort case, the court held that the amount of loss referred to the amount that the homeowner, the policyholder, must pay as a result of the loss. Justice Farmer, in his concurring opinion, specifically said, the policy uses the terminology, the amount of loss, in the appraisal provision in Part 4, damage to a vehicle. I do not equate the amount of loss with the amount the carrier must actually have to pay its insured. So the Fourth District Court of Appeal interprets the phrase, the amount of loss, which is the phrase that the citizens are relying upon, as referring to the amount the insured, the policyholder, is liable for as a result of the damage.
So, counsel, speaking of other DCAs, the third DCA recently in express damage restoration appeared to decide the issue that's before us. I know in your reply brief you contend that it did not, but and obviously we're not bound by that decision. But how is it distinguishable?
This is how. In the express damage case, well, on the facts, it's not distinguishable, but on the logic and the holding in the third district's holding, I don't agree with. The third district wrote, in its opinion, according to EDR, the appraisal provisions language narrows the scope of the appraisal by defining specific requirements of the appraisal process that are impossible once services/repairs are completed and are only possible with respect to existing property damage. Then it describes listing each item of damaged property, inspecting the damaged property. After stating the issue, that this appraisal provision has provisions that are impossible to comply with once repairs are made, it then goes on to its logic and holding, which is, as mentioned above, EDR's mitigation services are covered under the first part of the policy, Section 1. The appraisal provision is also contained under Section 1 of the policy as a condition to coverage under Section 1. The structure of the policy, therefore, indicates the appraisal provision applies to water mitigation services that are incurred to protect the property from further damage. The Third District Court of Appeal ignored this court's holding in, Henley versus Florida Motorcycle Training, Inc., where this court held that a court cannot interpret a contract based upon section headings when doing so would conflict with the plain meaning of the operative language of the contract. The Third District stated the issue, which was these provisions of the appraisal clause are impossible to comply with once repairs are made, stated the issue, and then said, based on the section headings, we're going to say that this appraisal provision applies to damages that have been repaired. I don't think they addressed the issue. I think they stated the issue, and then they stated their logic, and one has nothing to do with the other. And I think their logic of relying upon headings violated this court's opinion in Henley.
Counsel, you're well into your rebuttal
Yes, Your Honor.
time, but since I interrupted that, I will extend your rebuttal time by 2 minutes and, of course, provide appellee's counsel that courtesy as well.
Thank you very much, Your Honors.
Thank you. You may proceed.
Good morning. May it please the court. My name is Ryan Jones, and I represent Citizens Property Insurance Corporation. Your Honors, I'd like to start where the discussion left off, and that's with the Third District's decision, the express damage case, because that case addressed the exact issue presented in this appeal. And what the Third District found is that the very same appraisal provision that we are addressing here clearly and unambiguously applies to water mitigation services. That decision is not the only time the Third addressed that issue. There were actually 2 other express damage cases that the Third decided, all with the same result. And those decisions aren't wrong. When we look
Well, now,
at
those decisions followed the lead case, is that correct?
That is correct,
Okay,
Your
so those panels were obviously bound by the lead decision, absent an en banc decision
correct.
of the court. Okay.
Correct. And it is all the same issue, the same arguments presented. And the decision by the Third is not wrong. When we look at the existing case law and we apply that to the appellant's argument, it's real easy to see why the Third District made the decision that it did. If we start at the policy language, where the appraisal provision says It will address a disagreement over the amount of loss. There is no issue, no exception, no exclusion for water mitigation services right there. The threshold issue then is whether the water mitigation services are part of the amount of loss. And I believe appellant concedes that it is, and it has to be. If it's not, then it's not covered by the policy. But if it is part of the amount of the loss, then the plain language of the policy mandates that appraisal is available to resolve a dispute over the amount of that loss. And the courts have interpreted appraisal provisions as being able to address any dispute over the amount of the loss. There's no limitation to property damage solely and exclusion of water mitigation. It's not.
Factually, what we're talking about here are property damage issues, right? We had 3 trees on roof, garage. We had taking out wet insulation, wood flooring, drywall. I mean, these are property damage-oriented things, correct?
That's correct, Your Honor, and it's more of a technicality, the distinction between the two, because some of it is physical damage to property, the damage to the roof, the wet drywall, the things of that nature, and the other part of that, which is also part of the amount of the loss, are the services, the cost of tearing out the old drywall or drying out the wet areas of the house. That all comes together to be part of the amount of the loss.
Well, it seems like it's step 1 of repair and replace, or repair or replace, which is
Correct.
what we're talking about.
Correct. Dry it out first, and then repair it, repaint it, whatever else needs to be done to restore it to the original property. There's no distinction between those two aspects in the appraisal language itself. And there's really no distinction in the case law for it either. As a matter of fact, the 3rd District is not the only court to hold that appraisal is applicable in water mitigation cases. For example, this court in the MKL Enterprises case found that appraisal does apply to a mitigation company. The 4th District said the same thing in certified priority.
But those, and correct me if I'm mistaken, those, the issue presented here wasn't squarely presented in those cases, especially the first DCA case, right? So we don't have a first DCA case on point.
That's correct. This issue wasn't presented in any of the other cases where an appellate court applied the appraisal provision to mitigation services. The point that I was making is simply that appraisal has been applied to mitigation services. There's no history of this being excluded in the case law. There's no written text in the policy that excludes any of these services from the appraisal provision.
Counsel, I have just a practical question. So if the appraisal is not confined to existing property damages, how does an insured guard against, getting hit with a really steep bill if there's not an opportunity, and I guess I don't see an opportunity in these emergency repair situations to exchange estimates and, make a reasonableness determination in advance?
Your Honor, I think that is the absolute heart of this issue, because the way an insurer guards against that is through the appraisal process. It has to be allowed somehow to dispute the amount of the loss. And I think this exposes the main flaw in appellant's argument. Because essentially, if there's no way to dispute the amount that is quote-unquote incurred through these mitigation services, then appellant essentially names their own price. For example, they could do repair work for dry-out work that would normally cost $1,000 and issue an invoice for $1 million. And if the insurance company can't contest that, is it stuck paying $1 million for these services? I think that everybody would agree that's an absurd result. And the Supreme Court tells us in the Denny Associates case, we cannot construe insurance policies to reach absurd results. The way we get around that is to allow the insurance company to challenge the amount for the services, or in terms of the appraisal policy, the amount of the loss.
Right, but the appraisal provision speaks in terms of exchanging estimates. I mean, here there's no estimate. I mean, the work has already been done. So there was an invoice, services provided, and then the insurance company's audit of that. So it doesn't fit as neatly as I think that perhaps your client might like under the existing language.
It does. There actually is an estimate beyond. I think Your Honor is referring to the single-page invoice that says something to the effect of emergency services for $40,000. There's actually a more detailed breakdown of some of those services in the record, and it goes through the services that were provided. For example, the dry-out work, the tree trimming, the fans, and all of those have different line items with unit costs for each individual one. And I'd submit to you, Your Honor, that that is the type of estimate that's contemplated by the appraisal.
Okay, so that's what amounts to the estimate that you're referring to.
Yes, Your Honor, and what the appraisal provision itself says is that it shall include an estimate of the amount of any dispute that results from the covered cause of loss. It doesn't limit it to property damage, any dispute from the covered cause of loss. And I think this raises another very important distinction, because what appellant's argument does is it confuses policy provisions that address what can be appraised versus how to go about the appraisal process. The what can be appraised is answered in the very first sentence, which is a dispute over the amount of loss. That defines the universe of what can be appraised. And I'd submit that all of the case law addressing all of Citizens' appraisal provisions, there has not been a single one to find that language to be ambiguous. And in addition to that, it's very similar to all appraisal language. Essentially, they all use some derivative of that dispute over the amount of loss language. And the Florida Supreme Court addressed that in the Allstate v. Suarez case, and it specifically found that that appraisal provision is unambiguous, which is essentially the same language we're using here. So that, again, refutes appellant's argument. The remainder of the provision that appellant's addressing addresses how appraisal proceeds. And that is the mechanics of what goes through the appraisal process, the estimates that have to be exchanged, the inspections that have to be undertaken, and things of that nature. And I noticed that appellant addressed one of the issues about the inspection. The inspection is not impossible, and that doesn't change the fact of what can be appraised, but it doesn't make appraising mitigation services impossible. It actually helps the situation. Because if an appraiser can go out and see what area we're talking about, it will certainly help him or her to better assess the damage. As the court may know, these water dryout cases often involve air movers or fans and dehumidifiers, and the dispute is often how many do you need, how long do they need to be there. So for an appraiser to actually see the area and be able to get an idea of what that looks like, it's going to help him or her make a decision as to the amount. For example, if we're talking about a hall closet, that obviously is going to hold less fans and require less dehumidifiers than if we're talking about an entire floor of a house where all the drywall was wet and had to be torn out. So the inspection will certainly add something to the appraisal provision and doesn't do anything to preclude what can be appraised.
Counsel, let me ask you, so this provision, sub F under conditions, also provides a mediation alternative. So what are the differences between the mediation alternative and the appraisal alternative, and when does each apply under your interpretation?
The mediation provision, the appraisal provision are alternatives, as Your Honor said. Either one can be requested by either party at any time. The interplay between the two really, it doesn't affect the issue that we're here to address, but the interplay between the two is addressed by a statute and certain obligations in that statute of an insurance company to notify the insured when mediation is available or if that mediation is in fact available. So with respect to this, the insured is free to demand mediation at any point in time. And of course it is mediation, it is non-binding. So if mediation is unsuccessful, the parties can then proceed to appraisal. So the two are almost on parallel tracks. Either one could go first or second. I guess you wouldn't need mediation after appraisal because it is in fact binding, but the two can be used at the same time and are not mutually exclusive. Okay. So one of the other issues that I wanted to address is the effect of appellant's argument. Because what the argument's essentially asking is for this court to take away the ability to use appraisal to resolve any form of mediation dispute, or any form of mitigation dispute. And what that's going to do is it's going to fragment insurance claims. And what I mean by that is when you have an insurance claim, for example, any of the claims arising from the hurricanes or the tropical storms that we have here will result in property damage and a need for mitigation in most circumstances. If the property damage results in a dispute, or overall the claim has a dispute, the property damage can be quickly and easily resolved through appraisal without any burden to the courts or any need for litigation. But if there's no ability to appraise, as appellant is asking for, all of those disputes on the mitigation aspect are going to have to go to court. And that's going to be true for tens of thousands of claims that we have from all of the tropical storms and hurricanes that we've seen. And think about just in the past 5 years how many of these had. We've had Sally and Ada and Faye and Nestor and Michael and Alberto and Irma. That would result in an incredible burden on the court system to deal with all of these different claims. For that reason, it's not surprising that not a single district court of appeal has accepted this argument. And I'd submit that this court shouldn't either. The decision by the third in express damage was well-reasoned and well-supported by the case law. And for that reason, we're asking this court to follow that same decision and affirm the trial court's reasoning. And if your honors don't have any further questions, that concludes what I have.
Thank you, counsel.
Thank you, Your Honors. Counsel just pointed out why the third ruled the way they did. Public policy. I'm asking the courts to accept a caseload that they otherwise wouldn't have to accept. It's asking the courts to do more
This is a
work.
contract case. This isn't a policy case. It's
Correct.
a contract case.
You're right, Your Honor, and I appreciate you pointing that out. Public policy arguments have no place in this issue. And that was my point exactly. Thank you, Your Honor. The argument was focused on mitigation services. This issue is not about mitigation services. My client happens to be a mitigation company in this particular case. This is about repairs that have already been made and services that have already been performed. This is the difference between having to appraise an unknown amount versus appraising a liquidated damages amount. Appraisal does not apply to liquidated damages that have already been incurred. It is an alternative dispute resolution process that the parties use when they cannot agree on the amount of loss. The 4th District said in Dellisfort, once repairs have been made and the costs have been incurred, there is no dispute over the amount of loss, which it defined as the amount that the insured is ultimately held liable for as a result of the loss, regardless of how much the insurance company is obligated to reimburse the insured.
But can that really be right? Because this is a $40,000 bill, but it could have been $400,000 or $4 million. And it just is what it is what I'm hearing you say?
No, Your Honor, no, that's not my argument
Yes.
at all. The reasonable emergency measure provisions sets the limits of that coverage, and it says that they only cover reasonable costs incurred that are necessary. And reasonable and necessary are qualifiers that are used in PIP all the time. And those are the qualifiers that were chosen to apply to the we will pay language in the reasonable emergency measures provision.
Right, so, but the crux of the issue is who makes that determination, an appraisal panel or a jury,
The jury.
ultimately?
And that goes back to what I'm asking the court to do, which is accept litigation that they otherwise could send to appraisal. So, yeah, it's litigation. We're fighting for the right for access to the courts, not on behalf of mitigation companies, but on behalf of insureds who have come out of pocket, spent money, submitted the invoice to their insurance companies, and the insurance companies have said, no, we're not paying you because of one reason or another. And then they try to compel appraisal. That's something that's resolved by the courts, not an appraisal. Thank you, Your Honors.
Okay,
Appreciate it.
thank you. Thank you to both attorneys for your time today and your presentations. The court is now adjourned.
All rise.